Although no rule spells this out, physical evidence is relevant only if it is authentically the actual object involved in the acts giving rise to the case. A weapon found at a crime scene capable of having been used to commit the crime, for example, is relevant to the trial of that crime. But if that weapon is lost, the prosecution cannot substitute another one, even an identical one, at trial. The replacement is not relevant because it is not the weapon that was used. Authentication is especially important for documents and recordings whose content and authorship are at issue. Jurors cannot be exposed to evidence unless there is a rational basis for them to believe it is genuine. This threshold test for authenticity is the same test used for extrinsic acts evidence in United States v. Huddleston. Whether evidence is genuine is, like evidence of an extrinsic act offered under Rule 404b, a question of conditional relevance answered under Rule 104b. The proponent must, at a minimum, provide rational grounds for believing that the evidence is real. As Huddleston showed, this is not an especially demanding standard, but it does keep the jury from improperly taking it for granted that things are what they appear to be. Many authentication questions are settled through discovery. For example, a party's production of its own records and documents shows that they are genuine. Other authentication issues can be dealt with through requests for admissions or depositions. Certain categories of evidence are presumed authentic, and they are listed in Rule 902. Other objects and records must be authenticated, and Rule 901 gives several examples of how that can be done. Just about all evidence that is self-authenticating consists of documents. The first 5 categories embrace official government documents, records, and publications of all sorts. The details of the rule require seals or certifications, but that minutiae can be looked up as needed. It doesn't presently concern us. What matters is that forging official documents is difficult and harshly punished, and therefore unlikely to be an issue in the vast majority of cases. Similarly, official publications are unlikely to be erroneous and are easily verified. Note that privately published versions of government information, like commercial publications of the Federal Rules of Evidence, are not self-authenticating. For that reason, the Supreme Court opinions published in West Supreme Court Reporter are not self-authenticating, but the versions in the official U.S. Reporter are. Newspapers and periodicals are similarly difficult to forge, and it is very easy to verify their true content. The rule assumes regular professional publication to a mass audience and would not apply, for example, to an annual holiday letter summarizing a family's activities during the year for friends and relatives. Rule 902.7 applies to trade dress identifying a product's source or owner. A couple of old tort cases weirdly held that the labels on cans of Campbell's soup and Green Giant peas were not sufficient to link the defendant to the product. That view did not prevail, and those cases are anomalies. Dissenting in the Green Giant case, Justice Robert Williamson of the Maine Supreme Court gave the common law's rationale for the majority rule. Producers expend substantial money and effort into popularizing and protecting their brands, and there are stiff penalties for forging or misappropriating trade dress or passing off goods. For those reasons, brand labels affixed in the routine course of business alone afford sufficient basis to connect the product to the brand's owner under Rule 902.7. Justice Williamson apparently convinced the Green Giant Company itself of this. A 1955 advertisement proclaims that the Green Giant label is worn only by their peas. In Western states, 902.7 also applies to cattle brands. Notarized documents are self-authenticating because the point of a notary public is to verify the identity of the signatories to a document. Rules 902.9 and 10 essentially provide that anything presumed authentic by the Uniform Commercial Code or by federal law including, for example, filings made with the SEC, IRS, or other agencies, is presumed authentic by the evidence rules. Parts 11 and 12 deal with authenticating certain business records, which we study later. Parts 13 and 14 were added in 2017 to obviate the need to have a live witness testify that copies of digital records are accurate. The witness can instead certify that the records are accurate. Rule 901B gives examples of ways to authenticate documents and other objects that do not authenticate themselves. The primary way to authenticate something is for a witness who has personal knowledge to testify how he recognizes the item and whether it has been changed or altered in any way that could be relevant. Examples 1, 2, and 5 all illustrate this. Example 3 allows for an expert or, in matters of common experience, the jury itself, to compare a specimen whose genuineness is established, for example, of handwriting, blood, DNA, or ballistics tests, to authenticate another specimen as having come from the same source. Example 4 allows writings or recordings to be authenticated on the basis of their substance if they contain information known only to a few people and if circumstances indicate that the claimed source is most likely the author. The common law presumed that documents that were more than 30 years old and discovered in a usual place were authentic, mainly because of the difficulty of finding a living witness to authenticate them, and also because of the unlikelihood of fraudulent documents enduring uncorrected for so long. Example 8 reduces the period to 20 years. Example 9 explains how to authenticate the output of machines of all sorts, including X-rays, calculators, computers, and scientific equipment like breathalyzers. Whether a writing can be authenticated based on its distinctive features is determined from context and circumstances. For example, a letter or message responding to another can be authenticated if two conditions are met. First, the recipient of the response must have written to the purported source at an address belonging to or used by that source. Second, the reply's substance must include information indicating that it most likely came from that source. This is known as the reply doctrine. Any response in the exchange that provides a basis for identifying the author can authenticate the entire exchange. Objects with no distinguishing features, like drugs, can't be authenticated with only a witness's testimony, precisely because fungible items all look alike. For that reason, police investigating a crime scene will catalog objects they find before seizing them. The objects are then sealed in containers marked by the officer who sees them. The police or prosecuting authority stores the evidence, and notations are made each time it changes hands. Once an officer brings it to court, each person to have had possession testifies as to how he got the object, how he handled it and assured it was not tampered with, and to whom and when he relinquished it. Each person in the chain also testifies that the object looks to be in the same condition as when he had it. It is not essential that every person to have handled the evidence testify, but the testimony of the person who initially sees the evidence is usually necessary to link it to the case. The markings and records create a trail of distinguishing features that the witnesses can testify about to authenticate the item. When the evidence is not a physical object, but written or recorded information, the original is preferred over any copy, particularly if there is reason to doubt the copy's fidelity to the source. The preference for originals is called the best evidence rule, but it was long ago narrowed to only documents and recordings of whatever type: audio, video, textual, digital, photographic, sonographic, stenographic, pressed, engraved, or otherwise. When scriveners copied legal documents by hand, The best evidence rule guarded against errors introduced through manual copying. The modern rule allows for the admissibility of duplicates, provided that there is no issue as to whether the original itself is authentic or whether the duplicate is faithful to it. The best evidence rule now mainly excludes testimony about what documents say or photographs depict. The substance of a writing or recording is best proved to the jury by showing them the original or an exact copy, not by having a witness tell them about it. It is better for the jury to interpret the original document or recording than to have someone else interpret it for them. The rule does not keep a witness from testifying to something she personally witnessed that happened to be recorded. For example, a police officer can testify to a confession she personally heard made live without producing a recording of it. But if the officer knows about the confession only from the recording, then the best evidence rule bars her testimony about it. What counts as an original depends on the context. It means the document whose content is at issue, even if that document happens to be a copy of something else. For example, a note written on a photocopy of a contract is an original note, but a duplicate contract. There can be multiple originals of the same writing or recording under the rules. A duplicate must be an exact copy. For example, a transcript of a recording is not a duplicate because it is a transformation of the original into a different form, and errors can be introduced in that process of transformation. Not everything that has writing on it counts as a writing or recording under the best evidence rule. The rule is implicated only when the content of a writing or recording is at issue. Words or symbols meant only to identify an object or its source are not writings or recordings, but markings. The line between writings and markings depends on context. The shortness of the writing, its importance in the case, the potential significance of its exact wording, and the reliability of the alternative evidence are the principal considerations. Production of the original is excused when the original is innocently destroyed or lost, when a third party beyond the court's jurisdiction has the original, when the party opposing admission had the original and failed to produce it, or when the record is related to only a collateral or tangential issue. Original documents are also not necessary to prove the contents of voluminous records, such as invoices or receipts, when the relevant information can be summarized through testimony or in a chart or other exhibit. Of course, the opposing side must be given an opportunity to examine the underlying records and any summary exhibit before trial. Because the summary substitutes for the original documents, the originals must be admissible for the summary to be admissible. Rule 1007 provides that the production of an original is excused when the opposing party admits to its content in writing or in sworn testimony. The law of evidence seeks to minimize mistakes by preferring original sources of information. The law's preference for primary sources is reflected in 3 articles of the Rules of Evidence. The only question Article 9 seeks to answer is whether there is a rational basis for believing that the item offered as evidence is what the proponent claims it to be. The judge decides under Rule 104B whether this foundation has been laid. Without that foundation, the item cannot be admitted. If there is enough evidence to support a finding of genuineness, the judge must decide whether the evidence constitutes the content of a writing or recording. If it does not, then the item is admitted for the jury to consider. If the evidence is information contained in a writing or recording, then the best evidence rule applies. The judge must then decide whether the original must be and has been produced. If the original is required and its production is not excused under Article 10, then the jury cannot consider the evidence. If, on the other hand, the best evidence rule is satisfied, then there are yet more issues to consider.